Well, good afternoon and good morning, depending on where you're at, and welcome to today's webinar, Hospitals, HIPAA, and Impaired Driving Cases, a guide for law enforcement and prosecutors, hosted by the National Alliance to Stop Impaired Driving, established by Responsibly.org, and the National District Attorneys Association's National Traffic Law Center. The Hospitals and HIPAA monograph, which we have here on the screen, is referenced in this training, was a great collaboration between our organizations. Now, we use HIPAA a lot, but obviously, what is that? And that is the Health and Portability and Accountability Act of 1996. So you'll hear that a lot throughout the presentation. My name is Darren Grondell. I'm the Senior Vice President of Traffic Safety for the Foundation for Advancing Alcohol Responsibility, and also serve as the Director of the National Alliance to Stop Impaired Driving. I'll be your moderator for today's webinar, highlighting the importance of collaboration and partnerships with hospitals, law enforcement, prosecutors, judges, and others within the DUI system, obtaining critical evidence for DUI cases. Just as a reminder, like most webinars go for 1 hour, this webinar goes from 1 p.m. Eastern Time to 2:15, so don't drop off at 2 o'clock. So, because there's plenty of information right after that hour. As far as a few housekeeping items, this session is being recorded, as you heard the announcement as you signed on. We have over 375 people registered for this webinar, so thank you very much for the interest. We know that this is a topic across the country that we hope that we'll be able to ask, you'll be able to have some questions coming in that you can get answered, looking for ways to partner and work together collaboratively within your states and other jurisdictions. So we'll also be referencing the Hospitals and HIPAA document. The mics that you have are muted. You do have a Q&A box at the bottom that will be monitored, and then a chat box that will go to our host, or our hostess, I should say, and who is Kimberly Brown from the National District Attorneys Association. And also we have Christiana Falcon from the Foundation for Advancing Alcohol Responsibility. I know they're off screen, but they both have considerable contributions in helping us for this webinar. So we are monitoring those things. So if you have a question, Q&A box. If you want to just chat, there is a chat box in there as well. Just to get a little by way of background, the Foundation for Advancing Alcohol Responsibility was founded in 1991, or over 33 years ago, by the leading distillers, and we've invested over $300 million in policy development, educational programs and initiatives, and other resources, really focusing on our threefold mission, as it's noted here on the screen, is eliminating underage drinking with a number of programs from Ask, Listen, and Learn, Alcohol 101 Plus, really for the college level age group, and then We Don't Serve Teens. Focusing on areas about responsible drinking programs, we have a number of issues around that, particularly our virtual bar, which you may want to download using that QR code. And then also our main focus for me and our team and today is eliminate drunk driving and working with others to end all forms of impaired driving. As an organization, we were founded really with the focus of ending and eliminating drunk driving. And alcohol is our #1 priority as far as addressing and impaired driving. But in recognizing kind of some of the trends and the data in fatal crashes and DUI arrests, we also support efforts to address drug and multiple substance impaired driving, hence kind of the National Alliance to Stop Impaired Driving and today's webinar. In 2021, we founded the National Alliance to Stop Impaired Driving, really to help focus and help support states in prioritizing resources and other things and training, policy and other things, to really looking at the issues around multi-substance impaired driving. And I know in every jurisdiction you're seeing and challenging that. In combination, we have become a national thought and action leader, continually seeking ways to collaborate with our key partners to address the pressing needs to address impaired driving. As you may know, DUI is the only crime where we generally collect minimal evidence for criminal charges. And we need to change that mentality and change that philosophy or culture that we've had around impaired driving to begin really investigating these arrests, gathering more evidence and information so that we can actually address not just the crime, but also how do we help the individual? If we don't know what's going on inside, how do we help to address that long-term, mental health, substance abuse, all of those things. That's why I think this webinar is also another critical piece, is working together to address that. And then finding ways that we can, make our roadways much safer for our roadways and in our communities. Now, the National Alliance to Stop Impaired Driving, if we go to the next slide, Christiana, we actually hold conferences, and our third conference is coming up November 18th and 20th in Arlington, Virginia. If you came to our first one, it's going to be at the same hotel. And I think there might have been a little confusion out there, but the government rate is still going to remain at $350, and does not go up even after the early bird thing that you may have seen. That only applies to non-government employees, but government employees still $350. Please register. We'd love to have you there, and continuing some of the discussions that we'll have today. Now, the National Alliance to Stop Impaired Driving has a large membership, as well as an executive board with Jonathan Adkins as the chair. Our treasurer is Jonathan Adkins from the Governor's Highway Safety Association. And then treasurer is Deborah Coffey from Smart Start. And I'd like to turn the time over now to Kristen Smith, who is our secretary for the executive board.
Thanks so much, Darren. Hi, everyone. I'm Kristen Smith, and as Darren said, I'm the secretary of the NASID board. On behalf of our chairman, Jonathan Adkins, and our fellow board members, I'm really pleased to welcome all of you to this terrific webinar. It's wonderful to see such high attendance on the webinar, and great to see those numbers keep ticking up. Again, we're going to be recording this so others can watch it at a later point. I know that Darren gave you an introduction into NASID. We are a membership-based coalition of individuals and organizations dedicated to eliminating impaired driving, especially multiple substance impaired driving. So our membership includes law enforcement, prosecutors, judges, toxicologists, academics, and corporations. So as Darren mentioned, in my day job, I'm the head of road safety policy at Uber, where I lead all of Uber's proven efforts to reduce impaired driving. Uber, like dozens of other companies, is also a proud member of NASID. So thank you to everybody who is a member. If you're not yet, we encourage you to join, where it's through membership that we're able to put on great webinars like this. You can join at nasid.org. And just a reminder, again, another plug for our annual conference in DC, November 18th to the 20th. I'll be there, looking forward to hearing more about all the great research and studies that are underway in this area. So again, thank you so much for joining this as a board member, and also as someone who lost a loved one to a drunk driver. I really appreciate all of the work that everyone's doing to end impaired driving and the coalition that it takes to be able to do that. So without further ado, I'll turn it over back to Darren here, and we can get started on the webinar.
Thank you, Kristen. And I would venture to guess that many on this call have had some impact from impaired driving. And so that is the one thing that we strive to do, is to save lives. And so thank you very much, Kristen, for sharing that and for your remarks. So thank you. And let's get into the panel. We'll first start with Erin Inman, who is the director of the National Traffic Law Center with the National District Attorneys Association. Following her remarks will be Officer Jamie Derbyshire from the Montgomery County Police Department in Montgomery County, Maryland. And then following Jamie will be Melissa Shear, Senior Advisor, Traffic Safety Resource Prosecutor with the DC or Washington, DC Highway Safety Office. And then after Melissa will be Olga Kochar, Divisional Director, Laboratory and Transfusion Services at the George Washington Hospital. So Erin, I'll turn it over to you.
Thanks, Darren. Today we're talking about largely our hospitals and HIPAA monograph that we created thanks to the generous grant we received from R.org, the Foundation for Advancing Alcohol Responsibility. So thank you to them, as well as NASID, for hosting the webinar today. That monograph was a culmination of probably 2 decades of efforts between law enforcement, prosecutors, TSRPs, other traffic safety professionals, recognizing that there seemed to be a disconnect between the hospital personnel in the emergency room and law enforcement officers when they appeared and needed evidence for DUI crimes. Darren talked about the need for evidence in our cases in order to prove our cases, and some of that evidence may find itself in a hospital. So how do we react? How do we respond? How do we prepare for collecting that evidence? And what we'll cover today is it's a combination of training, communication, relationship building, and rinse and repeat. And Christiana, can you go ahead and go to the next slide? Before we get too much into the nitty-gritty of the Hospitals and HIPAA monograph, I wanted to give you an overview of what our organization does. Like Darren said, the National Traffic Law Center is housed in the National District Attorneys Association, and our mission is to help save lives on America roadways by helping prosecutors do their jobs. We also help judges and law enforcement and any other traffic safety stakeholder who is interested in the efforts that we put forth in saving lives on America roadways. Christiana, go ahead to the next slide, please. We do that by providing a combination of technical assistance. So perhaps you have a prosecutor who's new in your office and needs some basic questions answered about how to prosecute a DUI. They may email us. We have some resources, some monographs, some newsletters, and I'll touch on each of those in a little bit. We develop curriculums so that some of your trainers in your offices and your states can roll out that curriculum and not have to reinvent the wheel. They can teach law enforcement officers what we need as prosecutors in order to effectively communicate to a jury what they investigated and why the evidence is significant in a DUI case. I've talked several times about those traffic safety resource prosecutors. Every state has a program. Some of them are in transition in between TSRPs, as is the case with a lot of personnel turnover, but almost every state has a TSRP who is active right now. We do statutory compilations on a variety of topics, drugged driver laws, DUI laws, things like that. So get a hold of us if you need any of that. And we're just generally subject matter experts. There are 5 attorneys in our division of NDAA, several more in NDAA, but 5 of us who focus solely on traffic safety issues. And Christiana, can you go ahead to the next slide and I'll show everybody some of those resources that we have created. These are some monographs that we have created with just r.org. We have several others, but these ones we have created with r.org. And it is largely in response to the issues that we see come through our office with regularity. So if we get a lot of questions about toxicology and how to present that evidence in court and what does it mean, we recognize that a monograph should probably be made so we don't have to, so we can just send a more detailed response. And that's what a monograph is. It is kind of like a treatise. So it's a deep dive into a particular subject. And these are all available digitally through our website for free to anybody who is interested in it. The current one that we're working on, we're in creation for right now, is jury selection and impaired driving cases. And again, we put together a team of professionals from across the country who deal with these issues regularly. They're really experts who are in the courtroom and know effective ways in selecting juries in these impaired driving cases. Christiana, can you go ahead to the next slide? We also have a newsletter, Between the Lines. Anybody who's on this webinar, please sign up for this newsletter. It's all things traffic safety, primarily DUI related. We also have 4 times a year commercial motor vehicle issues that we publish. We have 2 attorneys who focus on commercial motor vehicle issues, commercial driver's license issues, and they actually have a free course coming up that I will give you the link to here in a little bit. So please sign up for that Between the Lines newsletter. It has a lot of great information in it, and it comes out monthly. Next slide, please. This is an example of one of our curriculum that is probably the most popular one that you may have seen in your state. You may have participated in either as an instructor or as a participant. And it can be a 4-hour module. We just updated it for the first time in about a decade recently. So this is a lot of fresh material for you and your law enforcement officers. If you're interested in having someone come to your office and present this training, I encourage you to reach out to us and or your traffic safety resource prosecutor so that they can help facilitate it in your local jurisdiction. Christiana, can you go ahead to the next slide, please? We also recently, this is about in 2020, we started a relationship with the National Association of State Boating Law Administrators. So we're just diving into creating curriculum and providing that training to law enforcement officers and prosecutors with regard to boating under the influence. Very exciting. Next slide, please. We have online training courses. So if you're a law enforcement officer and you know you have a new prosecutor or a prosecutor who's a little bit rusty in either driving under the influence of alcohol cases or driving under the influence of drugs cases, we have on-demand series of courses that are available at the pace and convenience of the local prosecutor. Oftentimes, prosecutors are drinking from a fire hydrant and they can't take time away from their office or their caseload to just devote 4 hours in one block or 2 days in one block to learn this information. So we've made that available online that you can take at your own pace. Next slide, please. As I said, we have some statutory compilations that we keep updated. Oftentimes we have legislators or TSRPs or prosecutors who want to go testify in their court, or I'm sorry, in their legislature about what other states are doing with regard to combating impaired driving. And so this comes in handy in that instance. But we've also found that these come in handy when prosecutors are writing briefs and they need support for those briefs and they want to let the courts know what other states are doing with regard to particular laws or what cases have been decided, for example, with regard to the admissibility of drug recognition expert testimony. So we have some compilations that can come in handy in those types of instances. Next slide, please. Again, we have a list of all those traffic safety resource prosecutors. We encourage you to work with them. Much of what we talk about today was created thanks to the efforts of several traffic safety resource prosecutors across the state. So when you open that Hospitals and HIPAA monograph, you will see that we had specific TSRPs who contributed to this project. But again, I say we have been addressing this issue for a couple of decades in the impaired driving world and encouraging everybody to get together, create a plan for how to handle this evidence, create those relationships, communicate with each other about what your needs and troubles are, and rinse and repeat. Next slide, please. I promised it. This is that upcoming course that we have for free, thanks to the FMCSA grant that we have, August 21st, 2024 in Charlotte, North Carolina. All of the transportation is paid for, and come and learn what masking is and how to make sure people who drive those large commercial motor vehicles are as safe as they should be. Next slide, please. I have thrown a lot of resources at you today. We have a whole lot more. This is a QR code. I'll linger here for a moment. Again, this is being recorded. You can either go to the website, you can open it with your phone and email it to yourself. This resource guide lists all of our current available resources. So I encourage you to check that out, see what else we have. If we don't have something that you're interested in, please let us know. We are happy to take requests and see what we can do about it. Okay, next slide, please. So why are we here today? This is an example, a video example of worst case scenario, what could happen if we don't prepare for working together. Let's see if it plays. And it looks like the audio isn't working. What happened here was a law enforcement officer came in and wanted information about a particular DUI suspect. And the emergency room nurse was doing her job and said, I can't give that to you under these circumstances. I don't just hand over private information of our patients. And law enforcement decided that it was appropriate, which it wasn't, to arrest that nurse for not cooperating with law enforcement. So let's go ahead to the next slide. Of course, we want to avoid these situations. That was that law enforcement officer who made that decision no longer works in law enforcement. Again, we want to avoid these types of situations, and we think they are avoidable by understanding what we do, law enforcement, prosecutors, emergency room personnel, understanding what each discipline does and how we can work together to achieve everybody's goals. And we went ahead and put that YouTube video in the chat for you, so you can check that out on your own when you have time. Again, that's just an example of what we want to avoid in these cases. Here is a QR code that will take you straight to the Hospitals and HIPAA and Impaired Driving Cases monograph that we've been talking about. So you'll have that for your reference. I'm about to turn it over to Jamie. And Jamie is a law enforcement officer. So she's going to talk about their perspective and what they encounter, what Jamie has encountered with regard to this issue, and why might we need information. Why is a law enforcement officer encountering personnel in the emergency room? Well, it could be a variety of factors. It could be that they are escorting a suspect to the hospital because they have a search warrant and they need to get a blood draw. It could be that the victims and the suspect have been hospitalized, and so they need to cooperate with the personnel at the hospital to either get a blood sample for toxicology investigation, or they may need hospital records. So there are a variety of reasons why a law enforcement officer may go to the hospital and want some information. And so I'm going to let Jamie talk about that. I know we were having some audio problems with Jamie a little bit earlier, so hopefully those have been resolved. As Darren said, Jamie is an officer with the Montgomery County Department of Police in Maryland. So Jamie, take it over.
Can you all hear me? Yeah.
I can hear you, Jamie.
Okay, perfect.
You're good.
Great. Thanks. Thank you all for having me. I definitely appreciate the opportunity to speak today and share some of my perspective and kind of the experience of the law enforcement officer with regard to some of these complex cases, because generally, as we know, these impaired driving cases are complex. And then when you put a hospital trip compounded into that, it makes it that much more complicated. Next slide, please. So when we just think about the impaired driving cases in general, I mean, they're tricky. They're tricky even in their simplest forms, right? They're tricky for law enforcement, but they're also tricky for prosecutors. And then, like I said, once you get that individual that needs to be transported to the hospital for medical attention, things change a little bit, right? Because those medical needs are placed above our investigative needs, and that's understandable. That's what needs to be priority once they arrive at the hospital. But you can't blame the law enforcement officer for thinking about that time factor that now is kind of indirectly or directly introduced to the scenario, right? Because as we all know, when it comes to substances, you know, as time passes, we're losing that evidence, and we're losing that evidence at a pretty quick rate, depending on what substance was actually ingested. But again, like we said, we have to pay attention to proper protocol, and we have to pay attention to the fact that those medical needs need to be placed above our investigative needs. But just because someone is transported to the hospital certainly doesn't mean that we shouldn't, as law enforcement officers, make our best effort to obtain key evidence. And just because it's a little bit more complicated, a little bit more intense, that we have to go to the hospital potentially to follow up with those, being able to get that evidence, it doesn't mean that we should just turn a blind eye and say, okay, well, I think we can make it without that, because it's important. It's important evidence that could be available to us if we just put in that little extra effort. Next slide, please. So you can see here, and I just put this in here, but this is actually, you can obtain it from that monograph, the hospital's HIPAA and impaired driving cases monograph that the National Traffic Law Center put out. There's a QR code there as well, but it just shows that complexity of those cases. The patient has to arrive to the emergency department, and this is all after the fact. If response time is factored in, and then fire and rescue gets there, they get transported. A lot is going on. A lot of time is passing. And as law enforcement officers, we're constantly thinking about that, especially with regard to impaired driving cases. Many states have a time limit in which that evidence can be obtained. In Maryland, for alcohol, we have a 2-hour time limit. And then with regard to drugs, we have a 4-hour time limit. And I believe a lot of states are similar in that regard. So it's important to know what your state's rules are with regard to that. But we are constantly thinking about what's happening with their evidence. Where are we on that timeline? And is it something that we're going to be able to get or not? And how are we going to go about getting that? Next slide, please. So one thing that's important with regard to what was being mentioned and kind of the whole topic today is HIPAA. And luckily, Melissa's here, and she's going to go over the whole legal part of HIPAA. But I think it's important for law enforcement to be able to understand the very basics of HIPAA. And I think the most important thing to understand is that it serves to protect the patients, but it's not a shield to criminal prosecution. So we are still expected to do our job, even though HIPAA is in place. And you can see here that there are exceptions to disclose personal health information to law enforcement under certain circumstances. And you can see here as well that a law enforcement official is defined as someone who's empowered to investigate or conduct an official inquiry into potential violation of law. So generally your law enforcement there, or 2, prosecute or otherwise conduct a criminal, civil, or administrative proceeding arising from an alleged violation of law. So your prosecutors. we are all entitled to that information. It is important to consider state-specific privacy laws. So states can have more strict laws that could prohibit or limit this to a greater extent. But that's something that if you speak with your TSRP, they would easily be able to tell you what laws are applicable in your state or your jurisdiction. Next slide. So I wanted to go over evidence just a little bit, since we are talking about hospitals and DUI cases. And like it said, it does get complicated once a hospital transport is involved. Obviously, blood and blood draw is our gold standard. It's our direct measurement as far as what's in the person's system at that point in time. Things to consider is, is a search warrant needed? I'm sure Aaron will talk further about, or Melissa, sorry, will talk further about some of the cases that have addressed search warrant and generally blood draws and in the invasive nature of these blood draws. And, that is a factor in consideration with regard to a search warrant. And then other considerations are, is an e-warrant system available? Are your judges trained in e-warrants, and are they able to get that done in a fairly quick amount of time, which is definitely helpful, especially with regard to impaired driving cases. And then lastly, and some things that we've run into in Maryland is, if you do need to get a warrant, is the person transported to a hospital that's within your jurisdiction? We have had fatal and serious injury crashes where the driver was transported to Washington, D.C., and that changes everything quite a bit when you're talking about warrants. And so it's important to know the protocols when it comes to that and neighboring jurisdictions, and dependent on the hospital that the individual is transported to. As far as medical records go, that is something that we often somewhat rely upon. Obviously, the blood draw is the gold standard, what we would prefer, but medical records are something that we have used in court before. It's just important to be able to speak to your prosecutors about how they would like to handle that, how they're going to decide to admit that evidence. Is it a business record, or is the ordering physician needed who ordered that tox screen or that blood draw? Sometimes it's needed that they're there to testify that it was a medically germane procedure. And then as far as the type of testing that's done, it's important to be aware as to what testing is done in the hospital compared to the forensic lab. And I'll talk about that in a later slide a little bit further. As far as oral fluid goes, that's another potential piece of evidence that would be good and has been helpful, especially with regard to drug driving cases. Very comparable to blood, especially when speaking of the laboratory confirmation samples, when it's actually confirmed in the lab, more so than just the screening devices that are used roadside. But you would need to know, as far as your jurisdiction goes, if that would be something that could be included as evidentiary value or not. And it is limited right now as far as what jurisdictions may or may not allow that to come in. Next slide, please. So some things to consider with regard to blood considerations is, and we run into this a lot because some of our officers do tend to opt for the request for the medical records as opposed to doing the blood kit. And it definitely brings about some problems and makes the cases a little bit more complicated than they already are. And I think obviously the blood kit, the warrant, those are all preferable methods. The blood kits are run in a forensic lab. They, are generally used for prosecutorial purposes. It's whole blood, depending on your state. And in Maryland, our traffic article requires that the conversion be done into whole blood and that blood alcohol content be reported in that value. And then in the forensic lab, generally speaking, they're using GCMS or gas chromatography mass spectrometry in order to be able to do that testing. So very, very reliable, very accurate, very specific to forensic testing. Your hospital blood, obviously, they have different purposes, right? They're there for medical purposes. These are run in a hospital lab. They want these results quickly. They need them quickly because they need to be able to know how to best treat that individual upon arrival. It's generally done in plasma or serum form as opposed to whole blood. And they generally use, depending on the hospital, enzymatic testing, which is quite different from what we're using in that forensic lab setting. So just important to know if you are considering medical records and, as opposed to the blood kit, just what some of the loopholes could potentially be. And sometimes medical records are not allowed to be admitted, especially for DUID. I know that in our jurisdiction for blood cases where we're looking at tox results from medical records, if we have drugs that come up, even drugs that are illegal like cocaine or PCP, if they come up, it's as presumptively positive. We're not even allowed to use that in court for violation of probation. So we generally are limited to alcohol results with regard to some of those medical records. Next slide, please. So as Erin stated earlier, that relationship building is key. And that's something that we've kind of learned the hard way, not just in Montgomery County, but I think, across the nation, as far as, having that plan, having an MOU or directives, or even a basic email to just clarify responsibilities, obligations, and agreements between law enforcement and the hospital is very, very helpful. You can do this by just getting together and sending out an email to the lab director and asking for a time to meet, or you could develop a potential, smaller or larger scale task force to be able to look at these issues and figure out all the major players, such as your state's attorney's office, your prosecutors, the hospital's law enforcement, so that when that time is a factor and when you're first arriving at the hospital, it's not something that needs to be determined then whose responsibility is what and how you go about obtaining this evidence. It's really helpful that if the hospital knows where we're coming from and we understand where they're coming from, that we all work together, and it's a much more seamless process if we need to grab that evidence, if we're all on the same page and we have unified understanding. One other option that I at least want to mention, I think that Melissa mentions it later as well, is just some law enforcement agencies are considering phlebotomy programs, and they have seen great success with that. It does help with regard to alleviate some of the issues. The hospitals are busy, and so to find someone that could be available to draw blood could be difficult depending on the night. But if you have a phlebotomy program and a certified phlebotomist that works for the police department or within the police department, or that's an officer with a specific department, it does help with regard to being able to obtain that evidence a little bit faster, with a few less loopholes with regard to that, since that is their primary responsibility during that date and that time. So that is all that I have as far as law enforcement perspective goes. It's just a little bit of a blip of a really big issue and something that we commonly deal with on a regular basis. I know that we are seeing, especially in Maryland, an uptick in fatal crashes or serious injury crashes where substances are involved. So I think it's more and more important that we have a good understanding with our hospitals and good relationships with our hospitals and a good understanding with our prosecutors as far as what our responsibilities are and how we can go about getting evidence as efficiently, but in a way that allows everybody to do their job and to look out for the interest of the individuals that are actually being transported to the hospital during that date and time. So right now, go ahead and hit the next slide if you would for me, Christiana. I would love to turn it over to Melissa Shearer, who will explain HIPAA much better than I can. And thank you for your time, and I appreciate your efforts today.
Hey, thank you so much, Jamie, for telling us all about the law enforcement perspective, and from everyone else who spoke before me for including me on this amazing webinar and this really important topic. And I'm happy to see that so many of you have joined us today. So as everyone said, I'm Melissa Shearer. I'm the Traffic Safety Resource Prosecutor for the District of Columbia. So if you don't know your TSRP in your state, please go to NTLC and identify who it is, because that person is a tremendous resource for you. I remember when I first started a long time ago, Aaron Inman was, who's the director of the NTLC now, was one of the first TSRPs that I met from Montana. And everyone is really collaborative and is going to never tell you that they can't help you with a question. So please take advantage of that. So now here's when the lawyer gets to talk about HIPAA. And the last thing I thought I was going to encounter when I became a prosecutor years ago was the intersection between being a prosecutor and dealing with hospitals as much as I have been over the years. But when you work in impaired driving for as long as I have, you're going to try to figure out how you can best get evidence in your cases when you might not have some of the advantages like a law enforcement phlebotomy program, because the district does not have one. So you want to make sure that you have a great relationship with your medical professionals, with your hospitals, and make sure that you educate your law enforcement as to not create a situation like we saw in the video, and that you can watch at your leisure to hear how everything went down. So you can go to the next slide, please. So When dealing with a hospital, law enforcement and prosecutors are faced with a lot of the legal implications that arise from HIPAA. Law enforcement don't always understand a hospital's role, and medical staff don't always understand the law enforcement's role. We know that law enforcement wants to gather evidence for their case, and we know that hospitals really, their main duty is to provide medical attention to that patient. And sometimes those parties don't really understand the importance of both of those roles, and it leads to confusion. Next slide, please. So what do we need from our hospitals? And it could be a sample of a suspect's blood or urine or oral fluid. The blood evidence is ideally what we're going to collect, because that's going to show past and current usage of drugs and alcohol and how it's really impacting the patient or the suspect's brain and behaviors at the time. But we can take, take advantage of other types of biological fluids that the hospitals might collect. In an investigation for law enforcement, it's best to collect things as quick as you can. As was described earlier, your drugs and alcohol are eliminating out of a suspect's body at pretty rapid rates. And so time is of the essence, and we want to get those samples collected quickly. But what happens in a crash scenario when a patient is coming through the ER and there really isn't time for law enforcement to collect that evidence right away, because there's dozens of different medical professionals helping to save that person's life, but there is a contemporaneous investigation that's possibly going on at the same time. We want to make sure that we're not losing some of the important things that law enforcement might need in its investigation. But either way, Jamie described earlier about getting medical records. We can always try to get medical records after the fact, but sometimes law enforcement really wants to get those specimens tested, because that's going to be the best evidence for us. Next slide. So this is what happens, where HIPAA sort of gets involved, and we want to call it HIPAA, not HIP with 2 P's A. There's a lot of confusion on that, but that's the Health Insurance Portability and Accountability Act. This all seems pretty straightforward to us, but when dealing with hospitals, there's a bunch of barriers that might exist in collecting our evidence. And one of the main barriers that you are going to encounter is HIPAA. A lot of medical professionals are going to tell law enforcement or prosecutors that they can't discuss things dealing with their patient because they are prohibited from doing so because of HIPAA. And as Jamie mentioned earlier, it's a there's the dance between whether it's a shield or a sword with HIPAA, and we can't, sometimes we can break through these barriers, but other times we're going to need some additional assistance from our courts to allow us to get some information from our patients. The privacy rule, the HIPAA privacy rule, provides federal privacy protection for individually identifiable health information, which is called protected health information, or PHI, and it's held by most healthcare providers, their health plans, and their business associates. And the HIPAA privacy rule really outlines how and when and with who personal health information can be shared. And it gives patients lots of rights with making sure that their protected health information does in fact remain protected. Next slide, please. So the HIPAA law was signed into law by President Clinton in 1996. It was created by Congress out of concerns for patient privacy, health, and insurance related matters. And HIPAA is a pretty big document. It has 5 parts, but today we're really just going to focus on Title II, which is entitled Preventing Healthcare Fraud and Abuse, Administration Simplification, Medical Liability Reform. A lot of words there. So HIPAA prevents the use and publication of private medical information without the consent of the protected patient. And it provides patients with control over the use and dissemination of their healthcare information. And it also defines the boundaries by which healthcare providers may or may not release that information to folks. And in this circumstance, we're talking about to prosecutors and to law enforcement. It establishes national standards with which healthcare providers must comply to limit the use of personal health information and to minimize the chances of inappropriate disclosure. So back in the day, you might remember, going to a doctor's office when you were younger, and The staff is just talking openly with parents in the waiting room about, this child or that child and what's wrong with this person, what's wrong with that person. HIPAA, in a very basic sense, changed a lot of which can be publicly talked about and disclosed so openly, just to protect our patients. Next slide, please. So it applies to covered entities, and covered entities includes healthcare providers. And keep in mind that law enforcement and prosecutors are not covered entities. Again, it goes back to these medical providers who are the covered entities. Healthcare providers may not disclose this information except under certain circumstances. It's not intended to prevent or obstruct legitimate police investigation, but it allows so it includes exceptions for healthcare providers to disclose information to law enforcement. So while law enforcement and prosecutors might not be subject to legal action under HIPAA, medical personnel could face civil and criminal consequences for inappropriately or prematurely disclosing protected medical information without a legitimate reason. Next slide. So the main exception that we're going to talk about today, and a lot of you probably use already in your state, is by getting an authorization from a judicial officer. So largely a search warrant or court order or a judicial summons or subpoena or whatever language you use in your jurisdiction, which a judicial officer has taken the opportunity to review the probable cause and to ensure that the officers are not encountering a fishing expedition, and that evidentiary standards are met, so that an officer isn't just walking into a hospital and saying, "Give me this, I'm a cop, I'm entitled to take it." So, the judicial officer is really going to be the gatekeeper in determining the legitimacy of the disclosure of this protected personal information from the patient. Keep going. In lieu of a warrant or other judicially issued document, an administrative subpoena may also be used to obtain access to the protected information. The information sought has to be relevant and material to the investigation. So in the occasion of a impaired driving offense, obviously the blood or the urine or the oral fluid or some other biological specimen has to be directly related to the investigation. The officer has to identify that they believe that the driving behavior was impacted by the person's consumption of drugs or alcohol, and that the blood or the urine that was collected is going to show evidence of a crime that had occurred. So the request has to be specific and limited in scope to meet its intended purpose. You can't ask for every single thing. You can't ask for blood that's taken maybe a week or so later. Sometimes the patients are in the hospital for a really long time. So what you really want is to make sure that you're going to get the specimens from that are collected initially when the patient is brought into the hospital, because those are going to be the most relevant to the law enforcement's investigation. Next slide, please. There are several exceptions included in the monograph that don't necessarily pertain to the investigation and prosecution of impaired driving cases and do not require medical professionals to provide the requested information. And one recent modification to HIPAA that is not in your monograph that you just want to be aware of is dealing with in the reproductive healthcare privacy space. And after the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization, which led to some bans, in various states on reproductive freedom, lots of individuals were leaving their state and going to another state where the reproductive freedom ban didn't exist. And so the Biden administration issued a final rule on HIPAA that strengthens privacy protections by prohibiting the use or disclosure of protected health information when conducting criminal, civil, or administrative investigations into a person that's seeking or obtaining or providing reproductive health care when such health care is lawful under the circumstances, or identifying any purpose for the purpose of conducting these investigations or imposing liability. So just be aware of, your state laws. Your states might have different restrictions onto HIPAA. They might allow for more leniency or more scrutiny into HIPAA. So just be aware of your state specific laws. When in doubt, contact your TSRP, consult with the National Traffic Law Center if there's anything specific that you have a question about. And so the next slide, please. circling back to the monograph and talking about relationship building is really the key to having your prosecutors and your law enforcement and your medical providers understanding the intersection between investigation and providing appropriate health care. The video that was shown earlier is probably sadly not unique to the state in which that incident occurred. In the district, there had been, some instances that had occurred years past where law enforcement assumed that they could, get specimens without probable cause, without reading implied consent, without all these different things. And medical professionals were reluctant to cooperate. They felt that their role was not to aid in the collection of evidence. And so we really needed to create a better understanding of what everyone's role is and how we can all work together. Because I imagine that, and Olga will talk about this next, I imagine that a lot of the medical professionals in your states really do want to reduce serious injuries and deaths that occur on our roadways. And they want to do their part in making sure that the patients that they treat obviously survive, but that they're not going to come back into the hospital again because they might have underlying addiction or other underlying issues or things like that. So they actually shockingly do want to help with your task forces and with your law enforcement and your prosecutions. And so the last thing I want to talk about before I'm running out of time is, and you can go to the next, we have maybe 2 more slides. Oh, actually I have 2 more slides. One of the reasons why, a lot of the police officers want to be involved in the collection of specimens from the hospital is so that they're the ones that get to testify in court. And so that the medical personnel doesn't have to come to court. A lot of times medical personnel doesn't want to get involved in the investigation because they don't want to leave the hospital for a day or 2 and have to testify in court, which can really impede their operations at the hospital. So if the hospital does entertain a search warrant to draw blood from a patient or to collect blood from patient otherwise, make sure that the law enforcement officer is the one that observes the needle sort of going in the arm of the patient so that any chain of custody issues are not impacted and the medical professional doesn't have to come to court if it goes to trial. We want to avoid having more witnesses than we need to, taking into account the 6th Amendment. Obviously, certain witnesses need to be there, but if we can limit the number of witnesses that the prosecutor needs to call, that would be a better scenario. And then last but not least, I want to just talk a little bit about law enforcement phlebotomy, and there's lots of great resources at the National Traffic Law Center. If your state is considering a law enforcement phlebotomy program, Jamie mentioned it earlier, rather than using the hospitals or the medical centers as a vehicle to collect your blood, if your police agencies actually have phlebotomists on hand, then it avoids the need to having to take your suspect or your patient to the hospital at all. Law enforcement phlebotomy programs allows law enforcement officers who have specialized training to draw blood for investigative purposes. And so it might be an implied consent blood draw. So the patient or the suspect, him or herself, is saying, yes, take my blood, or it might be through a search warrant. Maybe they're refusing to provide the blood. And so a police officer obtains a search warrant from a judicial officer and then is able to take the blood draw back at the police station rather than having to take them to a medical facility. So consider having a law enforcement phlebotomy program if your statute allows for it. Some states only identify who is able to draw blood. So you might want to look at your laws to see if there's if they're broad enough to allow law enforcement officers to collect blood. So there might be some legislative changes there, but I would encourage you all to looking into a law enforcement phlebotomy program. I think Kim has popped that link into the chat, and that's that. I had a lot to talk about in my slide. The lawyers are always very, very wordy. So I appreciate the opportunity to be here. I'm going to turn it over to Olga from GW University Hospital, just down the street from me in DC, who's going to talk a little bit about the medical perspective. So thank you all so much for having me.
Thank you everyone for joining. Thank you, Melissa, for the introduction, and to my amazing panelists, of course. I know that we've heard a lot about the other side of the moon, for me at least, but now you'll get to hear a little bit about the hospital perspective on things as well. If we can go to the next slide, Christiana. So for all of us, you guys as well as us, it's a balancing act on collaboration. So we all went into your profession or my profession because we wanted to help our people, we wanted to help community, but at the same time, we all need to be regulatory compliant. And that balancing act sometimes gets very tricky. If we can go to the next slide. So let's talk about some general considerations for the blood draws and kind of for the hospitals and what we need to know before I feel we can have a collaborative relationship. There is an increase in a law enforcement demand for blood samples. And just like Jamie alluded to and Melissa also spoke about, is that there is, of course, a direct measurement test from testing versus testing blood for the content of blood. So the direct laboratory measurement test of blood is the best versus, for example, a breathing test or a few other tests that are available on the market. But before we even go on into blood draw and before we even start talking about sampling, we need to consider a few things. So let's talk about kind of things that are on a background that are important for you to know, so you can trust your laboratory, you can trust the hospital, and you can make sure that your samples can withstand the scrutiny of the court. So first and foremost, I would ask you to please see consider some of the regulatory things, for example, certifications and some of the accreditations that your hospital laboratory may have. All of the hospital laboratories, all clinical laboratories must be CLIA certified. Some people will tell you that they're CMS certified. It's one and the same. CLIA is the Clinical Laboratory Improvement Amendments that their main focus is quality laboratory testing. So CLIA is the basis of all clinical laboratories. So if somebody tells you that CLIA accredited, that doesn't mean that much because it is a highly regulatory field, but not as tightly regulated as by some other folks. For example, most laboratories would be College of American Pathologists accredited, and I'll go in a second, we'll go over why that might be important, or Joint Commission accredited. Those are voluntary accreditation. So we went to the College of American Pathologists, so we went to Joint Commission and said, you know, we're doing a wonderful job here. Our quality is very tight. We are focused on quality and patient safety. Can you please come and inspect us and grant us your accreditation? If the hospital laboratory has that accreditation, that's the first sign for you that they're trustworthy laboratory because of what is involved in getting accreditation, and then of course what the pain kind of that the hospital laboratory goes through to get to the accreditation. Next slide, please. When you start the conversation with your hospital, please ask for a face-to-face meeting. I feel that we had a conversation with our law enforcement counterparts or colleagues, and this was not going as productive as when we actually sit down and discuss what are we trying to achieve. It is very important to develop these relationships, and you'll hear from me in a little bit of why that's important. Identified also who is the best person to communicate with from the hospital or the hospital laboratory. Who you're going to communicate with, what you're going to communicate, and when. Why is this important? It's because hospitals, of course, are 24/7 organizations. However, leaders of those hospitals are not 24/7. As much as I would like to be there for you 24/7, it's not possible. So unfortunately, what will happen is something can get through the cracks because we reached and the difference, it was only a couple of hours. You really need to understand hospital policies as well. The hospital might not be willing to disclose those policies to you in writing, but they definitely can share what those policies are with you. For example, understanding the hospital sample preservation policies is very important. So how long we're going to keep that first sample that you need when a patient was admitted to emergency room, and a hospital or laboratory specimen discard policies, how quickly the specimen will be discarded. Most hospital laboratories are pressed for space, and as a result, we're discarding specimens relatively quickly. They become irrelevant in a patient's clinical care. So from our standpoint, they're now for the lack of a better word, useless, but for you, they still hold something. So please make sure that that is clear to you, the sample preservation policy and the discard policy. It is also important to understand the chain of custody. And the reason why it's quite important is because you want to make sure that that sample at every point was tracked appropriately. Even if you collected, even if you're present when a specimen was collected in an emergency room, you most likely will not be allowed to follow the laboratory all the way to the laboratory, load the samples on an analyzer, wait for the result, see what happened to the sample, and so on and so forth. Of course, you'll have to trust us that we're handling the specimen appropriately. A lot of this information can be in your hospital LIS system, and it's available to those of you who are collaborating with you from the hospital side. But again, you need to know that information. And of course, ask some of the big questions. So most of the hospitals do not have chain of custody necessarily, because again, we're not we're not law enterprises, right? We are only a clinical laboratory. So we have some information, but not all of the hospitals keep track of it, and not all laboratories do. So please make sure that that's available to you. Ask questions on how secure is the particular lab. So we are, for example, my hospital is in Washington, DC. We are very secure for a number of different reasons. We also are just a few blocks from a White House. So all of those things make us a little bit more serious about our security than maybe some hospital in a smaller community hospital kind of setting in some of the rural areas of the United States. So understand that. And of course, who has the access to the sample? I'll tell you why that's important. The reason why you assume that the sample is handled appropriately, but it doesn't always happen. For example, as part of the College of American Pathologists, I go on the laboratory inspections all the time, and I have seen one hospital where samples were kept in a hallway. It was not a secure hallway either. So all of the sample refrigerators were in a hallway because there was no space left in the laboratory. So of course, if the samples are in a hallway versus behind a closed door, there is more chances that those samples can be, played with or tempered in some way. So please make sure that you understand where the specimens are stored. There is a different kind of attention to security. So please check with each individual hospital, even if they're within the same geographical area. Their policies, their security policies may vary. So let's talk about some other questions that you might want to ask. So for example, can you as an officer or somebody on your behalf look at the laboratory quality control and calibration procedures? What does it mean is, for us, it means that we run quality control with every set of the samples we run. The reason why it's important is because we know what value we expect out of our quality control. So when we run a quality control, we're looking for that expected value. If it's not of that value, those tests that were analyzed together with that quality control are not good, and we need to start over. So that's important. The second question to ask is there any proficiency testing? Why do you think proficiency testing is important? So proficiency testing is part of the regulatory compliance for laboratory, and College of American Pathologists that I mentioned and Joint Commission always ask for us to participate in a proficiency testing. So proficiency testing validates your testing numbers in comparison to all other like laboratories. So it really allows us to be independently test a specimen with a known value, and those values high, low, everything in between, so we can verify that we truly can produce quality results for the appropriate patient. There is another question you want to ask is, can you see or can the laboratorian speak to the last two proficiency tests? Why am I asking for the last two? Most of the proficiency tests have them once every 6 months. So when you ask for the results of the last two, it means that the laboratory has been stable and run a quality testing for at least a year, which is a very good indication for you to be able to trust that laboratory. And then of course, the preventive maintenance for the analyzer that the tests are run on. That's important to make sure that the accuracy of analysis is preserved. Again, for those laboratories that are accredited by Joint Commission or College of American Pathologists, the PM is a must. It's a regulatory requirement. So that also gives you kind of an additional, the second laboratory tells you we are College of American Pathologists accredited or Joint Commission accredited. That gives you that extra kind of comfort with the laboratory results. And of course, you can ask about validation. Most of the assays should be validated for that particular laboratory on our particular, with our particular assay on our particular patients. Why is it important? Is because things vary from geographical area to geographical area slightly. There are certain things that can contribute to, for example, high results. So you definitely look at all of those during your validation process. So again, when you are working with your laboratorians, and I'm asking you as a laboratorian, I understand that, but please focus on collaboration and not intimidation. I think that's incredibly important. Whenever there is this force that's coming through the laboratory, I think it can create quite an uncomfortable feelings. And I don't think you would be able to succeed without the laboratorian really collaborating with you. The reason why I say that is my laboratory, for example, runs over 2 million specimens a year. It means on a daily basis, we run about 6,000 specimens. If you feel that you will be successful without us pointing you in the right direction, finding that one sample that you're looking for, probably not so much. And the reason why you want to collaborate with your laboratory, so you understand how easily you can track the sample, where was it stored, why it was stored, by whom it was stored. So those are kind of some of the simple things that we need to remember. So we all would like to collaborate with each other because we understand the importance of this program for the community and for the health of that community. However, there's always some barriers to collaboration to consider. So necessity versus not my problem. For some of the laboratorians who are extremely busy and who are extremely tired and a lot of them work 7 days a week, we're very short in our community, professional community, just like you guys are short in yours, it becomes one more task to deal with. It becomes extra work. And I think there has to be a conversation of why this is so important for us to focus on this and what it allows us as a community to accomplish. Specimen collection. The specimen collection must be accurate, and I know that a couple of my colleagues already spoke about that. It has to be an appropriate site prep, so there is no, so your results, again, accurate and your numbers reflect exactly what happened at that point in time in the patient's blood. Specimen tracking, which would help you as well as it will help us. So it helps me feel comfortable that I know where the specimen was at all times. It helps you knowing that the laboratorian understands where the specimen was and they produce you the specimen that you're actually looking for. Laboratory storage capabilities, we discussed that a little bit. Warrant process. The timelines of the warrant process can be tricky. And I know that Melissa already talked about timelines. Timelines in this particular situation, times is not your friend at all. Please remember to try and work on such a process with your hospital laboratory that allows you to preserve the samples first, so they're not discarded. And then it will allow you a little bit more time to focus on the actual warrant, for example. And you can come and get the specimens. But the first sample is to have that process built into your collaboration with the hospital laboratory, that our samples are actually pooled and saved so they don't end up discarded. One of the other kind of processes that is a little bit challenging at the hospital is the risk mitigation and hospital risk management, as well as the legal departments. We all know that, as Melissa spoke to, the kind of the cumbernesses of HIPAA law, and I think there is some interpretation as pretty much in everything. So I think for the hospitals, they're really focused on protecting ourselves and protecting our patients' privacy to make sure as it's just a simple risk mitigation tool, nothing else. So the risk management and the legal department want us to succeed as well, but they need to do their due diligence before they can allow us to release the sample. So kind of work with those departments as well, or your laboratorian can do that on your behalf to make sure that that process is smooth. And then, of course, we talked about, again, understand what the understand what your laboratory need. So make sure that you have that relationship, and then make sure that you kind of know what everybody's looking for. That we are not a criminal laboratory, we are clinical laboratory. So we need to know from you, what are you looking for? What do you need from us, and what documentation you need from us? And you may need to talk to your criminal laboratory to understand that what is it they need from the sample that we are providing. So what type of sample they need, what actual analysis they can run on each sample, and so on and so forth. And once you understand both sides, then we'll be able to collaborate much more collegially, and I think much more fruitfully as well. So what are the collaboration barriers to collaboration are there? I think the understanding of the hospital and laboratory practices is a must. Tracking the requests that do come from for some of the samples, I think tracking of the request is quite cumbersome, since most of us rely on fax machines still. It's 2024, but we're still faxing. It's incredible. There is always a discussion of professional versus family and community responsibility. So all of us are working in the local communities. For some of the people who are in this emergency department, some of my phlebotomists, they may know the person who is brought in. So there is always that kind of a friend and a family tie versus a professional tie. So those are all barriers, however small they may be. The hospital security should have a very good relationship with the law enforcement, and in my hospital it happens to be so. So it makes it much easier for us, because we have that backing of security, and we always feel that we can always rely on them to sometimes just communicate with law enforcement, so we're all speaking the same language. There is such a thing as quality not sufficient. That's a big barrier in the hospital laboratory. Quality not sufficient means the first time around, when we first went to the patient, we did not collect enough blood. It is a real thing, which means that we might have collected so little because the patient might have bleeding actively. We did not want to collect more. So there is a number of different kind of reservations of why to collect more blood. So quality not sufficient is something that you may be faced with from time to time. If you're requesting samples and you're getting an answer that quality was not sufficient every time, that's a concern. And I think you need to go back to the drawing board with your laboratorian representative. But if it happens occasionally, it is something that we see from our standpoint in a clinical laboratory, of course, as well. And then again, understand if there's any special considerations from either side, either from the criminal laboratory or from the laboratory, hospital laboratory, so they can help out with kind of breaching those. So those are a few things that you need to consider as barriers to this collaboration. And again, in conclusion, I would just let you know that I really would recommend you to become collegial and friends with your laboratorian, with your local laboratorian. And in Melissa's case, it was me. We are really much friendlier than we sometimes look on the outside or sound on the phone. So please make that effort in person. And then, of course, make sure that you all understand why this collaboration is important. I think we're all working towards the betterment of the community and to keeping our community safe. And it's as important to us in a hospital as it is for you guys. So again, thank you so much for joining, and I hope I did not bore you. And I thank you from my perspective, since I'm not a law enforcement professional. I really do thank you for everything you do every day and for putting yourself out there just so my kids and I can sleep safe at night. Thank you so much.
Well, thank you, Olga, and thank you to our panel. I know that we don't have a way to have you all clap your hands and give the round of applause to our panel, but I'll have them all come up on camera now. But I think kind of in summary, you've seen a lot of good information and resources that are available to you, as well as the importance of what we try to do at responsibility.org and with the National District Attorneys Association, National Traffic Law Center, and the groups that are represented here is how do we help to bring not only just to training to you, but also to build relationships. I think in summary, you can hear kind of that overarching theme of how important it is to build relationships, partnerships, communication. Oftentimes people will change. You have new supervisors and so on and so forth. So it's kind of a repeating process that is going through and helping to keep those relationships building. And sometimes, when I was a trooper, when I was going through some of our, those critical incidents and everything else, the comment was made, if you are meeting for the first time at a critical incident, it's too late. So having that ability to meet, kind of do some scenario building, having some discussions, having templates in place or policies and procedures that are in place, that if there is somebody new, that they can go over to what the policy is and they can read it. Because what we don't want to see is somebody walking out of a hospital in handcuffs, which I hope never happens. But ultimately is that building those partnerships. And I had a question, I guess, for the panel is for you, I mean, when I was a trooper, we have areas where there was multiple jurisdictions, multiple counties, so there might be various hospitals, or you might be on a state line where I had a case where I had was a serious injury crash. She was impaired. By the time I got there, because the area was so large, it's right on the Oregon border. The closest hospital was in another state. So, challenges that way. I don't know if anybody wants to address that, but I think another part of that is that you may have that relationship building with other states, other police agencies, that they may have to be the one that draws the blood for you in another jurisdiction. Aaron, Melissa, I don't know if you, Jamie, I don't know if any of you want to pipe in on something like that.
Everything you said is accurate and true, Darren. And I imagine Melissa, I mean, my jurisdiction is huge. The one that I worked in, Montana, oftentimes it was cross-jurisdictional boundaries with regard to counties, because our county was larger than the state of Rhode Island. So even then you have the county sheriff's office in one jurisdiction, the county sheriff's office in another jurisdiction. And we need to have worked out ahead of time, not just for DUI cases, but for all sorts of cases that we may investigate, how we want to handle that. Melissa, I imagine your jurisdiction is extra special because you're in the district and you abut states. And I also want to note that the monograph does talk a little bit about cross-jurisdictional issues. Melissa.
Yeah, I'll say that, in DC, we're so close to Maryland and Virginia, and we have county hospitals really, or state hospitals in Maryland and Virginia, but really only private hospitals in the district. And there's a diversity of understanding between those three jurisdictions. And we have 30 some different law enforcement agencies in the district, and some have authority to enforce things outside of the district. Our park police, for example, can go into Maryland and Virginia. So they sometimes will use, if the incident happens in DC, sometimes they'll go to Maryland and Virginia to take the patient to, even for something as simple as just a blood draw, not even for emergency services. So my sense is that it would be really a good idea if you're in these sort of cluster areas, like the DMV, that you do work on these regional task forces, not just an interior task force, so that a lot of communication can be done sort of within a larger geographical area than just your immediate town, so that you're starting to work on building relationships outside of your jurisdiction as well.
Thank you.
Darren, we do have a question from one of the attendees,
okay,
from a law enforcement officer, indicating that when he goes to the hospital and requests patient condition so he knows how to proceed with his case, is the hospital entitled to claim HIPAA and not give me patient condition? Specifically, he's only looking for condition of, did the patient die? Is the patient possibly going to die, or it will not be a fatal case? Melissa, I think that you touched on this a little bit. Maybe you can address that question.
Yeah, so I would say that HIPAA does sort of allow for you to give a general update, stable, in surgery or something like that, but it can't go beyond what the condition is. That they suffered a wound to their liver and their blood alcohol level was a 0.15 or things like that. But I think a stability answer, the person is stable, the person is in the ICU, that's a fair answer to give to law enforcement or to family, unless I would say the patient, him or herself, is able to say, don't disclose any information about myself. So Olga, would your hospital agree with that statement? or no?
Absolutely. I think absolutely you're correct. It's a general statement, but nothing in particular. And one more thing to remember for you guys, and this is something new that hospitals are starting. We are now starting a pre-hospital transfusions where we transfuse whole blood at the scene as the means to increase the survival rate for these patients. And that's something for you as well, something that you might need to start thinking about and asking about, was there pre-hospital transfusion? Because obviously that will affect the blood alcohol.
And if I may, I want to expand a little bit on that question that we have and ask Olga and Melissa your perspective on flipping the question around a little bit. Is the law enforcement officer entitled to that information from the hospital staff? Let's say we have a new person in the emergency room who is erring on the side of caution and protecting their patient's privacy. What do we do in those circumstances? How can we prevent something bad from happening there?
I guess always err on the side of not providing that information, because you want to protect the patient, and you also want to protect the hospital from any sort of civil or criminal liability. So erring on the side of not disclosure would probably be the best bet. In reality, what happens is a different story, but I would always err on the side of not disclosing that.
I think that probably most likely what would happen in the hospital as well. And I think, again, just like I spoke about the relationship between the local security for that particular hospital and law enforcement, I think that conversation can also help and also allows the medical professional to feel a little bit more comfortable. So I think when those conversations can be navigated with the local security director, for example, in our case, then that can be also helpful. And that can be an additional way of providing some guidance in a moment.
But if the officer was going there to obtain blood, would that change that? You know, especially if they were a suspect in a DUI case, would that change that?
You mean knowing the condition of the patient?
Yes.
I mean, I would say that if they're obtaining blood and let's say the patient is not in a position to consent to it because they're injured or in some way, and you know, we know that the Supreme Court has recently ruled on, not so recent anymore, but has ruled on exigency and blood draws and whatnot. You know, the law enforcement, especially in the states that have e-warrant systems, can get a warrant pretty quickly to get that blood draw. You know, lots of laws allow for the withdrawal of consent once the patient is in a position to withdraw that consent. Let's say they make a recovery, they can always withdraw that consent. But if the law enforcement has that search warrant and they're able to get the blood, then they're protected from a withdrawal of a consent or a suppression of that evidence because they've had a judicial body review it first.
Okay.
Jamie, did you have anything you wanted to add? I'm really curious to know what you have to say about it.
Yeah, I mean, I do think that, and I would imagine where that question is coming from as far as status of the patient is, you know, a better understanding as far as where the investigation is going to go. Are you calling out your collision reconstruction unit? Are you calling out your fatal crash team? And the sooner that you can do that and close the road down or open it back up, if you're not calling them out, it is important for public safety, traffic safety, and officer safety as well. So I understand the need for being able to get even just a basic status update on a patient, just so that we can determine which way the investigation is actually going. More so even that than the evidentiary value of, you know, do we need to get specimen from that individual or not, but really just to do our job correctly and do our job well, even on the roadside aspect of things, not so much just the evidentiary collection in the hospital per se.
I think that is the key part here is that each other knows why. It's not that we just are coming in to demand information. It actually triggers a whole series of events after. If it's just like a serious injury crash, you know, are you going to paint the scene, put in PK nails, start measuring, doing all that kind of stuff? Or if it is going to be much more serious, it does trigger, like Jamie said, fatal review teams, you know, all those things get triggered. So if the hospital kind of knows that piece too, and even also the officers knowing what happens on that other part. So that's another key piece of really understanding each other's, you know, what's happening with the work. I would just say that, you know, there was a comment here by Stacy, and I'm not going to pronounce your last name correctly, probably Grazik, But it says in Vermont, we would have the hospital draw it and hang on to it until the warrant was obtained. So is that another option that could be done, you know, as they come in before they start putting in all the other, maybe the transfusions or, you know, medications and those kind of things that might hamper the investigation. So that's another piece of this too, is they understand kind of what those requirements are. So interesting. So
Darren, there's one more comment. It's not really a question, but it sort of
Yeah.
illustrates the concept of the relationship that you need to establish between the parties. And it's from a law enforcement officer who says that we are often the first responder and are, quote, partners in care, which means a clear transfer of information in both directions. In similar cases, the patient comes in without an ID and the LEO is expected to provide name, DOB, and social security number to the hospital. This information is also confidential but readily shared by officers. The give and take is necessary on both sides. And that is the final comment and question that we have.
yeah, and that's very true. Oftentimes we're the ones that may be identifying for the hospital who that person might be. So yeah, great comments, great information. I know we're out of time. We've gone over even what we've allotted, and so which means that's great. I really appreciate the panel again for your expertise in this work. If any of you out on this call would like to connect further with them, all the contact information will be provided here for you. We will have a post email that'll be coming out with the recording, links to all of the references that we mentioned and additional information for you. If you would like to have any of the team members here present to your team or present at a state conference or any of those things, we'd love to have you connect with us, and so that we can continue these discussions, because this is an important element as we move forward in this work of saving lives. And it takes great collaborations and partnerships. The last thing I'll just share with you is, again, our conference again is in Arlington, Virginia, November 18th and 20th. Please register right away. Again, all government employees are $350. It's great registration fee, and all the hotels, or the hotel bank, is at a state per diem rate. It's $193. So please register, come and join us, engage in these conversations. And what it will allow us also is, what are some strategies and what are some things that we can do moving forward to enhance not only these relationships, but all of the relationships in our DUI system approach. So we'll have a recording coming out to you soon. Also, to learn more about NASID, go to the nasid.org, and you can learn more about us and about multi-substance impaired driving. And even if you'd like to join NASID as a member, there's a little link there for you as well. So on behalf of all of the panel, thank you very much. You were amazing and awesome. I've switched you over to another screen. That's why I look like I'm looking over to the side. But on behalf of responsibility.org and the National Alliance to Stop Impaired Driving and the National Traffic Law Center and all of our panel, thank you all for all that you do in your respective jurisdictions to save lives and making a difference on our roadways every day. So thank you, and let us know if you have any questions or other things later on. Looks like there's a question that just came in. Do you want to handle that one, Kim? So with that.
The question is about continuing education certificates. We will be working on that. So you may be eligible for credits.
Perfect. Well, thank you very much, all of you. Be safe and have a great rest of your week. Bye-bye.